Army says it will respond after studying ₦1 billion Nnamdi Kanu compensation judgment. The Nigerian Army may have started yet another season of Python dance at the moment, following the order of a court that the leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, be compensated with ₦1 billion for total violation of his fundamental human rights. Counsel to the Army, Amos Story, Wednesday, January 19, said the military would respond after studying the judgment. An Abia State High Court, sitting in Umuahia, had ordered the Nigerian Army to pay ₦1 billion compensation to Kanu for invading his house in September 2011 during Operation Python Dance 2. The court also ordered the Army and federal government to apologize to Kanu in 3 national dailies for the infringement of his fundamental human rights following the September 10, 2017 military invasion of his house. Justice Benson Anya, who gave the orders while delivering judgment on the suit filed by Kanu against the federal government, the Army, and 6 others for allegedly violating his fundamental human rights, declared the raid as unlawful. Kanu had, through his special counsel, Aloy Ejimako, filed a suit against the federal government, the Attorney General of the Federation, Abubakar Malami, the Chief of Army Staff, COAS, and the Inspector General of Police, IG, for violating his fundamental rights. Other respondents are the Director General of the Department of State Services, DSS, the Abia State Director of DSS, the State Commissioner of Police, and the Army Brigade Commander, Ohafia. He sought, among other reliefs, a declaration that the military invasion of his building and premises at Isiama, Afaroku, Ibeku, Abia State, on September 10, 2017 by the respondents or their agents is illegal, unlawful, unconstitutional, and amounts to infringement of the applicant's fundamental right to life, dignity of his person, his personal liberty, and fair hearing as guaranteed under the pertinent provisions of Chapter 4 of the Constitution of the Federal Republic of Nigeria, 1999, and the African Charter on Human and People's Rights, Ratification and Enforcement Act. Justice Anya, who read the judgment from 10:05 a.m. to 11:09 a.m., declared that the issue of military invasion of Kanu's house on September 10, 2017 was so notorious that the court cannot turn a blind eye to it. He said that the federal government, the army, and other security agencies made flimsy and ineffectual denials of their involvement in the said invasion instead of proving otherwise. The judge put a poser to the respondents. Assuming you were not responsible for the invasion, what steps did you take as government and agents of state responsible for the protection of all citizens, including the applicant, to investigate the invasion and bring the perpetrators to book? Justice Anya held that Nigeria is an integral part of a community of democratic nations who must respect human rights, adding that violence, adoption, and torture do not resolve but fertilize conflicts. The court further advised the federal government to embrace dialogue and political solution in handling the issue of Nnamdi Kanu in the interest of peace. The court, however, declined Kanu's prayer to return to Britain, his country of abode, before his rendition from Kenya. It also said that he lacked the competence to abdicate on the issue of Kanu's abduction in Kenya and extraordinary rendition, saying that only federal high courts have jurisdiction over extradition matters. If you enjoyed this, please like, share and subscribe so you can get notifications.